Thank you very much. To the extent that's the first time it's happened under the Fourth Republic, it is a significant precedent. But I think it's unfortunate, whichever way you look at it. If the Chief Justice was guilty of the offense charge, it's unfortunate. If she was not guilty and the process was unfair to her, it's even more unfortunate. But as a country with a growing democracy, the issues about conflict in opinion or conflict in philosophy between the three arms of government is really bound to happen. And so in America, it has happened so many times. It continues to happen. But the way in which these things are resolved is to use most of the processes provided in the law, but hardly ever to touch that sacred impeachment process. And the history of our own country is clear with that. The first president of Ghana, Dr. Nkrumah, had occasion to actually dismiss Chief Justice Adom-Otchere on account of a ruling that the court had given. And it occasioned a disagreement between the president in terms of his view of the matter and the courts that heard it. This had been an attempt, a bomb thrown at the president, and you can understand the president will be quite emotional about that. A bomb thrown at the president's investigations suggested to him that his foreign minister, the Honorable Adom-Otchere, and his information minister, Adom-Otchere, were both involved in the plot. And so that would look like a big betrayal. So the president must have been quite emotional about that. The matter went to court, and on account of the evidence before the court, the decision was made by Adom-Otchere that these two gentlemen were not guilty of the offense. However, others were guilty. There were other people who were charged. The president was infuriated by that and decided that he will sack, just dismiss. There was no process at the time. Just dismiss the Chief Justice, which he did. And in that constitution of 1960, there were limited powers granted to the president of Ghana to participate in legislation, to make laws. So the Osajifo decided that he will access that process and then actually went to pass a bill in Parliament, which became law, permitting the president to be able to remove the Chief Justice and justices of the Superior Court of Judicature. In pursuit of this law, the president proceeded to remove some other judges in subsequent situations. So it was clear that the president of Ghana could do so. Many people didn't like it, and it affected the social fiber and the way the democracy was working at the time. Anyway, good or bad, the coup came. So if you look at the 1969 Constitution, which is the constitution that came after the 1960 Constitution, there was actually no provision for and there was a provision that said that no one can remove a judge of justice or the Superior Court of Judicature or the Chief Justice and all of that. It was very, very tight in 69 Constitution. The reason was that they were trying to correct this horrendous situation of the first one. Now, in that, in the short operation of that Constitution, there was major disagreement between the executive and the judiciary. The president and the prime minister, who carried executive power at the time, and his people had decided to sack some top civil servants because, as it were, they were resetting. In those days, they call it purging the system, but they were resetting. And the reset took them to remove 658 civil servants. One of them decided that, look, I'm going to challenge this.
That's Salah.
Salah went to court and challenged it, and it was a big issue. The Supreme Court ruled. In fact, there was a major preliminary application about bias here and there, and it was resolved. And then the big ruling came, and the Supreme Court held that the Prime Minister does not have the power to do so and so. It's offended the Prime Minister, and that always happens. But there should be no discussion of, I will remove you when I get you, or it should be a discussion that uses the other remedies, if you like, rather than this very sacred removal. So then the government, legislative, and the judiciary is bound to happen, or the judiciary and the legislature. But the way constitutions have operated across the world and the way in which we hold these constitutions, hardly do we talk about we are going to remove somebody. In 1979, the situation was similar. There was a Chief Justice called Justice F.Y. Apaloo. But there was a coup d'etat between 69 and 79. And during the coup d'etat, the soldiers, when they come to power, they banish the executive and then they terminate parliament, but they leave the judiciary to work, except that they leave the judiciary to end at the Court of Appeal, often no Supreme Court. So this was the situation in the 79, the interregnum between Champon and Akufo and all that, and then the elections of 79. So Apaloo was Chief Justice. The Constitution of 79 said that for the superior judges of the Superior Court of Judicature, any judge who was already a judge, High Court, Court of Appeal, Supreme Court, no Supreme Court, so High Court, Court of Appeal. Any judge who was already a judge before the coming into force of the Constitution will remain a judge as if appointed under the Constitution. This was the provision that was in contention in the court. Now, the CPP guys had won the election. They felt that FY Apaloo was the opposite. He was UP, and they were not quite sure about working with him. So they thought about getting him out. There was a provision in the 1979 Constitution, Article 124, which is the same as Article 146. So they could have used that process. They knew they could have used that process available to them. But because that process is such that you don't really often touch it, you leave it until it is very, very, very critical to do so. That's why the provision is there. It's not a provision that you tinker with every 5 years or every 10 years. Anyway, so they saw that Article 124 the provision was there, but they didn't want to use it. So what did they do? They decided to find a way in which they can manipulate the transitional provisions and the new constitution. So where the transitional provision says that anybody who is a judge will remain a judge, and Justice Apaloo was the Chief Justice, but part of the Court of Appeal because there was no Supreme Court. And the judges who were elevated to the Supreme Court were elevated as if they had been appointed under the Constitution. What did they do? They nominated Justice Apaloo for the position of Chief Justice. He was already Chief Justice. He was then nominated again by the President. And the nomination sent to Parliament for vetting. When Justice Apaloo appeared at the vetting, he told the committee that he doesn't think he should be here because he's already Chief Justice. Under the transitional provisions, he remains Chief Justice, and therefore, he's Chief Justice and part of the Supreme Court automatically. The appointments committee said, well, the President has asked you to come. It's up to you. Do you want to do the interview or not? He said, I'll do it. So they took him through the vetting process. The verdict came and he had failed the vetting. This is the way they tried to go about it because they wanted him out. They knew that they had Article 124. So they said, Apaloo has failed the vetting. Apaloo then decided that, no, I will take an application before the Supreme Court and ventilate this matter. Eventually, he went to the Supreme Court and he won. And he remained the Chief Justice of the Republic. But this is what the CPP guys tried to do. But they knew that they had Article 124 in their Constitution. They could have started the Constitution, bring somebody to file an application, refer it to a committee, go under Nkrumah and get him out. They knew they could do that, but they didn't want to do that. Then came the...
But why, in your view, do you think they didn't want to do that?
That's a point I'm making, that these articles and provisions...
But in our situation, we've touched this particular provision a number of times. Peter Adom-Otchere and all of those...
I'm coming to that.
We've touched it,
yes.
so...
Yes, so you see, when I say touch it, I mean something that looks like orchestrated by politics. That's really what I'm saying. If an individual, in the case of the dairy one, it's a different matter. It's not executive or another arm of government, or it doesn't seem that it's politically motivated. It's a completely different matter. On such occasions, you may be able to do it. But I'm also talking about touching it in respect of the Chief Justice, not as other Supreme Court judges. The Chief Justice, that one, that's the big one I'm talking about. So that was 79. Then we came to 1992 Constitution, and we imported the provisions of Article 124 into the 1992 Constitution, which is
now as 146.
As 146. The first major brush between the executive and the judiciary under 1992 was the ruling in 31st. It was a ruling that rubbed Mr. Rawlings on the very wrong side. And it was all said that one judge, a former Attorney General, NYB Adade, was responsible for what was termed the coup d'etat at the Supreme Court because he led the majority opinion of 5 judges. And it was said that it was he who convinced from Benjamin, who in the afternoon during the conference was still in balance. He was looking left or right. And it was Adade who convinced from Benjamin to become part of the decision, as they put it, against Rawlings. In his sessional address to Parliament in 1994, Flight Lieutenant Rawlings found occasion in the sessional address to berate the judges and almost give a warning. And that is the extent to which he was upset with the ruling. Article 146 was there. They could have occasioned an Article 146 petition against NYB Adadi, against other judges, and remove them from the court. They could have done that. But because it is rarely touched, all Mr. Rawlings did was to speak about it in Parliament, in the sessional address. We have to be mindful of the fact, as I'm making the point, that there could be an error of judgment on the part of the Supreme Court. That's very possible. They are not infallible. So there could always be an error of judgment on the Supreme Court. In fact, there are those jurists who feel that Nkrumah's decision to remove Kosa was genuine, because if you look at the accounts of what happened and the interactions between some of the accused persons and those who were convicted, you really can't find why you convict this and not convict the other. There are some jurists who feel that. So the Supreme Court may have been wrong in 31st. It's entirely possible. The Supreme Court may have been wrong in decision A or decision B. That happens, it's happened all the time. The law is replete with these things where decisions are overturned. But even if they are wrong, the way to manage it is not to rush to the Constitution and find Article 146 and take them out. The problem that, the case goes on from Rawlings, you know how Kufuor was completely outraged about the Chikata decision. President Kufuor had come into office in 2001. The NPP had campaigned on corruption in a big way. The NPP had wanted to show Ghanaians that they were serious about corruption. So something like oral, what they did was that we are setting up special courts. It will catch all the thieves and deal with them. It is called Fast Track High Court. It's very fast. This one, they won't go there and waste our time. It's very similar to oral. So it was a campaign thing. So they came into office and they needed to respond to their base. So they set up Fast Track High Court. It was held all over the place. And those days when, if you live in Adenta, there was a big washing bay there. He puts his big there, Fast Track washing bay. And everybody was talking about it because the word fast track became, something sexy that the youth was talking about. Then Mr. Chikata, one of the arch rivals of the NPP administration at the time, is to be prosecuted. The prosecution is laid before the Fast Track High Courts. There's political bragging that, okay, now we have Chikata, he'll go into the Fast Track High Court, it will be fast, blah, blah, blah. Then Mr. Chikata goes to the court to challenge the fast track itself. It's like somebody take an application to court today to challenge oral, and people talked about it. And then the court rules in favor of Mr. Chikata. The Supreme Court, sitting as 9 judges, 5-4 decision in favor of Chikata, to, as it were, outlaw the fast track high court. Huge decision, big one. Mr. Kufuor was concerned. The MTP administration, the Attorney General, they were very concerned. They could have said, oh, is that how this Supreme Court is going to behave? Article 146. Let's go and deal with it.
But there should have been grounds for it. These were judicial decisions.
But that's the point I'm making, that a lot of the times, when the Article 146 comes, and that's why I have Sal here, when it's political, it is not about what has been written. It is a decision that has been taken to remove this person or that person, and then they find it. When it's political, it's not. They will not come and write that you made a decision in this case. No.
So they'll find a reason.
They always find a reason. So when you give a ruling like that, that hurts the politics, or that makes people upset in a political sense. Clearly, in a political sense, this fast track ruling was about politics. The decisions that Justice Torkonoo made in the
vacation,
of
seats.
Yes, the vacation of seats matter. It's robbed the NDC on the very wrong side, in a very political way. Since Justice Torkonoo has been removed, there's been important people on social media who have celebrated her removal as a result of SAL. The Santrofi, Akwafu, Lolobi, and Likwe situation. And I've been looking at that situation critically. I don't find where Justice Torkonoo is being held responsible.
So you hold it there. Let me go around the table and I'll come up.